Good morning. Welcome to the Mississippi Board of Nursing, our board meeting. Before we begin, I would like to ask Mr. Drew Calhoun to lead us in prayer.
Let's go to the Lord in prayer. Lord, thank you for today. Thank you for this opportunity to do your work here at the Board of Nursing. I pray that every decision that is made, every conversation that is had, as the discussion is had, Lord, that we would honor and glorify you in everything that we do. In your name we pray. Amen.
Thank you. Thank you, Mr. Calhoun. So at this point, we're going to do a call for order. And at this time, I would like to take a roll call, beginning to my right of the board members in attendance.
Drew Calhoun.
I'm sorry for my left. I apologize.
You were looking at
Vino Priscilla.
Beverly Oliver. Janelle Moody.
Jeremy Cummins.
Sandra Culpepper.
Danny Blanton. Lacey Gentry.
Dr. Renee Dodson.
Nancy Norris Johnson. All right, so at that point, we have a quorum, and we will begin with requests for approval of the agenda. With that being said, I go ahead and request the amendment now. Yeah. So at this point of approval of the agenda, but however, we would like to make a change on number 2 under that 2.3. We would like to move the legislative update to above 2.1. Would anyone like to make the motion?
I'll make that motion that we make the changes as stated.
I'll second.
All those in favor? All right, at this point, we will move to the open forum, and we will begin with Mr. Bobinger with the legislative update.
Just slammed in on 2 wheels. The Senate's actually still in session down there today. A little unusual this late Friday. They've got a deadline coming up next week to get all the bills that came out of committee passed off the floor. So they're working pretty hard. We have a lot to talk about. I'm trying to follow my executive director here, Dr. Johnson, and brevity, try to make it somewhat brief. There is a lot. I do appreciate our staff working with me and certainly Ms. Clanton on the legislative committee. There's a lot going on. I'll try to be brief and just touch on some things. We'll probably follow up after the deadline next week, and Shane, you and I worked on this, probably send out a list of bills to you after we get through the deadline to kind of see what's still there and what's pending. We've had some news to develop. Public health is very interesting, particularly in the House. I thank some of you, our presidents there, along with staff. And I know Ms. Clayton, you attended some of the board meetings as well. Board meetings, committee meetings. First bill I wanted to mention is House Bill 849. This was introduced by Chairman Creekmore, who is the House Public Health Chairman. It started out with the anesthesiast assistants, I think, were in it, and some other groups, CRNAs, I believe. This bill was amended in committee to basically do away with collaboration agreements for all APRNs, nurse practitioners, as well as CRNAs. It would also add a CRNA to the board, this board of nursing. That's what it proposed. That was done in committee in real time. It's kind of surprised a lot of people. I think a lot of folks were surprised that came about, but it did, and it passed. So that bill is alive and it's pending on the House calendar. That's House Bill 849. So elimination of collaboration agreements, and it, just so you'll know, without going into too much detail, it would require 8,000 practice hours, which is the number of hours. Of course, y'all know it's a fluid process as you go through the legislature. But that's a bill you probably want to watch. We'll continue to monitor it. House Bill 1430. I call it the weight loss drug bill. This is the issue, the special call meeting where the Administrative Code Committee took action. And as I understand, not only the committee approved it, full board approved it. Senator Becky Curry introduced this House Bill 1430. It basically addresses that same issue. I think, quite frankly, the thinking is they wanted to kind of keep this bill alive to make sure the OLRC, that we have to get all our regulations on the state agencies approved by that. They're going to approve this prior, to make sure that this bill's not necessary. It's still alive. It's pending on the House floor, but it's House Bill 1430. There was a lot of discussion. I know the legislative committee under Ms. Clanton had discussed this. I think there was at least one Zoom call, maybe two, about other issues as well. But the House Bill 1415 and there was also House Bill 1051. They're basically the same bill dealing with certified nurses aides, the CNA bill. One was by Ms. Curry and one was by Ms. Stacy Hobgood Wilkes. This is the bill that would have transferred the administration of those 18, Dr. Johnson, 1,000 plus CNAs from Department of Health to this board. A lot of discussion about it, a lot of attention on it. In the end, the committee considered it. In the end, I think the thought was we're not going to do it at this point. I think they had several reasons they were looking at. Not saying in the future that may not occur, but the House Public Health Committee at this time decided not to move that bill. But it's 1415 and 1051. But obviously, we had done a lot of preparation in case of that. I know Shan had already jumped into high gear on projection of cost and what it would take and require to properly regulate those folks. So we were prepared if it moved forward to try and accommodate that and do what we need to do. But like I said, that may be an issue again next year. We'll just see, but that's where we are at this time. This is an interesting bill, House Bill 927. Midwifery, provide for license and regulation of. This would actually create a new board for midwives. But as I understand it, Dr. Johnson, feel free to watch in. We regulate, as I understand it, certified, nurse midwives, certified nurse midwives. This is a different category of individuals that would be licensed under the Department of Health. No, I'm sorry, they would have their own board. And I saw it start last year, but there's been some momentum in this area about, pushing more for midwifery and people to do this. Now, there were some good questions I asked about emergencies, breech births. Some of you were in that meeting. So there were some good questions asked, but there seemed to be a resolve on the committee to at least keep alive and move it forward. And we'll see what the Senate does, but did want to, make you guys aware that bill's alive and still moving in the process. We have Senate Bill 2248. That's the Fresh Start Act. Y'all familiar? It's been around every year. They want to tweak it. This is, I think, at least the intent or purpose is to try to give people a second chance, and with some shortages in some different healthcare areas, including ours, to maybe have better workforce or more opportunity. The thing we've been concerned about, we voiced it last session, and we had it in when the bill died, and we got taken out, but is that the nursing licensure compact, our compact is very important. We have all these surrounding states. Our people go out of state, people come to Mississippi. So we want to keep that in place. This current version, I believe, and I think Brandon had looked at this as well as staff. You know, it exempts the nurse licensure compact from the provisions of that Fresh Start Act. We just want to make sure that stays in there and stays in the proper form where we don't have any disruption with our compact. That's our concern there. And we, you know, the legislature, I think, has worked with us on trying to do that. We would continue to follow this bill. It's still live until 2048. But this is another bill that's interesting. There again, I know Dr. Johnson and this board, I think you have formulated a plan dealing. I know one plan, there was a provision, our appropriation bill, right, Shan, on military folks and trying to expedite licensing and all. There again, I think everybody on this board, certainly we're looking at a veteran here that we want to help our veterans to do things. But what is the ultimate goal of the board? Patient safety, right? Patient protection. So as long as we're balancing those things, we want to help our veterans. This bill is House Bill 1262. It applies, as I read it, to LPNs strictly. If they've received certain training, like an Army combat medic specialist, a hospital corpsman, or a United States Air Force aerospace medical service specialist, that's enough. If these people have that training and 2 years of practical clinical experience, not sitting behind the desk, actually, then they would be qualified. There's more details. I'm just giving you the overview. They would be qualified to sit for the exam, to take the licensing exam. Of course, the board would still have all its authorities as with any other applicant. I guess it's just something we need to look at. Again, Dr. Johnson, I don't know if you have any comments, but we just want to watch it again and make sure that we've got our people properly trained. We know our military does a good job with training medical personnel, but we just want to make sure that they meet requirements that are satisfactory to the board. And like I said, for patient safety, that's House Bill 1262. This was an interesting bill, House Bill 924. Shan, I think we had spoken about this. I think you're aware. It would create a state board of health professions. There would be 6 professions on here. This would be an interesting group, Mr. Cummings, if it passes, but it's Board of Medical Licensure, Pharmacy Board, Nursing Board, Chiropractic Examiners, Dental Examiners, and Optometry Board. They would all live together to form a board to coordinate with each other, to look at possible when conflicts arise, scope of practice issues. I think the intent was to try. My real intake is, let's put these folks together and at least have a vehicle for them to try to resolve some things before we all go to the Capitol. You know, and all our groups start dropping their individual bills, saying we want this. I think this is an attempt by the legislature to say, look, we want to form this, put you guys together, at least have periodic meetings where you can talk about issues that you may have. So it's a concept. It's still alive, and House Bill 924.
Trey,
Yes.
so a board to regulate the boards.
But what the membership would do comprised of
Yes,
representatives from each of the
Yes.
boards,
yes, sir. Yes,
not
sir.
independent. Okay.
Yeah, that's kind of interesting, isn't it? And I'll have to double check, Mr. Castillo, there might be an independent pick or two on there, but it looked to me primarily focusing on those board representatives from those boards.
Did you name the Board of Nurses in that?
Yes, sir.
Okay.
Yeah, Board of Medical Licensure, Pharmacy, Optometry, chiropractors, dental examiners and optometry. I can't believe I remembered all 6 of them, but those are the ones. This bill got very interesting, and was kind of a surprise to everyone. I think you would agree, Shan. House Bill 1437. This is the Board of Medical Licensures omnibus bill where they're cleaning up, doing some things with their licensing. In public health, there was a committee substitute offered, which includes APRN, full practice authority, or however you want to term it, removal of collaboration agreements, got placed into the Board of Medical Licensure bill, omnibus licensing bill. So that was interesting to say the least, but that is still alive. So to be clear, I mentioned that earlier bill and this bill. So there's 2 different House bills that have the nurse prac CRNAs a part of those bills. So those are still alive. Now, assuming they pass the House, which they should, it's got to go to the Senate. So that may be a different story. Look, it may not be. We'll just have to see. But I wanted to mention that. Real quick, Shannon texted me earlier. I was actually watching the Senate Bill 2075. That is the Board of Medical Licensures omnibus licensing bill, where they're cleaning up, doing some things internally for their board. That's their purview. I just wanted to clarify, the NPs and CRNAs are not a part of the Senate bill. That was just the House bill I told you about. So that is their licensing bill in the Senate, 2075. There is a bill that I want to look at closer, want to make you aware of. It's Senate Bill 2749, Community Health Workers Establish Licensure Program by Department of Health and certain divisions related to. It's a lengthy, somewhat lengthy bill, but I'm not exactly sure what the parameters are going to be on these community health workers, but we're going to do some more delving into that to see exactly. Obviously, it's got to be unlimited. It's got to be limited because, we're not talking about obviously other regulated healthcare providers and professions. So, but that bill is alive. There's a No Patient Left Alone Act. Some of you may have heard about that, House Bill 403. This kind of goes back to COVID, Dr. Johnson, I think, where people couldn't get in to see dying family members and that kind of thing, allows a patient to designate a certain person that can come in and visit with them, but it does provide still some discretion. Facility is just, I think, trying to find a balance between protecting other patients, employees, as well as respecting the rights of the family members. That's House Bill 403. And I think that concludes. Like I said, I could go on with some more, but I saw Dr. Johnson look at her watch. So I'm trying to, but I do want, I like to keep you guys informed on everything going on. So, and I did see, Ms. Oliver, I think I saw your name and Ms. Gentry on the confirmation list too, for your confirmation to the board. And there was also a LPN replacement confirmation there, I think, as well. And I think it was the formerly Alton Shaw's position. Those were listed on public health as well. The delivery certainly more efficient.
Confirming,
What's that?
I believe that's the position that Drew Woodfield was out.
Nelson,
Yes,
look at him mention.
Oh, yeah.
he was RN at large, so I believe
Yeah, this is-
that's a
Have
position.
you received notification? That's what I'm saying. He hadn't received his notification.
Yeah, I'll look back at that and let you know. I think, and they can add to that, but those, I just wanted to mention that I noticed just quickly looking at the committee, the items listed under Senate Public Health. There's also the Senate Bill 2275, which talks about the, I guess it'd be consolidation of state agencies and services. Shannon, didn't we see a bill like this last year as well? It didn't go anywhere perhaps the prior year. They always talk about consolidating to save money for office space and IT services. And there again, I know how this board operates.
We run a fight ship, our finances are in really good order. There again, you know, we're all for saving money, but we also want to maintain the integrity of our individual boards as far as carrying out its duties and responsibilities. So that would also be, you know, something that we will continue to watch. And there are a few other boards that kind of touch more on administration and operations and agencies in general. And we can add those to the list too. I think Shannon's aware of those, and we've been watching those as well. So, any questions?
Do you know the date of the confirmation?
No, it'll be up to the discretion of, a lot of times they'll wait later in the session, honestly, to bring those up. And but I'll certainly try to give you a heads up. Normally they reach out, you know, and you'll reach out and say, be here at this time. But don't worry for the new appointees or the current, usually they don't grill you more than 3 to 4 hours.
Oh, okay. That's good.
It's either very fortunate, they've already, your committee's already done the background, so y'all, you know, existing board members, so it's not that bad. Well, anyway, thank y'all very much. I appreciate it. If you need anything or have questions, please feel free to reach out. Thank you.
Thank you.
Okay, right, hold on, just,
Go, Trey, I just want to have everyone recognize you. If you haven't seen Trey at work, go to the Capitol. That is one of the hardest working men I've ever seen up in the Capitol, and I really do appreciate everything that you do.
I appreciate that very much.
thank you, Mr. Bobinger.
I got 99 problems.
All right, so next we're moving on the agenda to the Mississippi Library Commission presentation.
Ms. Terry?
Are you gonna take a picture?
Of course, somebody will. Take it, but I put my camera. Okay, come on, get videographer, photographer. Look at you standing there in front of us. So for those of you that don't know, Ms. Terry is here representing the Mississippi Library Commission. If you will just read what the certificate says, Ms. Terry, that would be helpful. Yeah,
Summit Award, Certificate of Excellence in State Document Management, presented to the Mississippi Board of Nursing. Best state document by a small agency. Mississippi Nursing Magazine, Fall 2024, Volume 16, Number 3. Hewlin Bivens, our Executive Director.
so we were recognized as one of the best small agents for that documentation. So thank you. But we'd like for all the board to come around, take a picture with Ms. Terry, and this is a testament to the hard work that you all do in your leadership. So we appreciate that very much. And we thank the Mississippi Library Commission
And more would be here today. We apologize, but we are in the middle of an extensive PLD training.
Yes, I was informed about that, but Ms. Terry was, they wanted to send somebody and Ms. Terry was available, so we appreciate you taking the time out. So if all of the board members will please just kind of surround them, might want to come out front.
Let the tall ones behind us.
Yeah.
Because we're kind of. Yeah, yeah.
Get jaded. Y'all look cute.
Hey, can we also, get a picture of the person who is in charge of the magazine? That would be Dr. Johnson, Dr. Burns.
Brandon, that'll be the whole staff.
There you go, Sarah. You're on the phone.
Okay. Noted and appreciated, staff. You absolutely deserve to be in this picture, so thank y'all.
Thank you.
Appreciate y'all.
Thank you.
Christina's card and the pictures, you could just,
Okay, I sure will. Thank you.
So once again, thank you, Mississippi Library Commission, for that honor. And it is a great honor because we have a lot of contributors here on the staff and board members that make the journal a wonderful piece. With that being said, the next agenda item is if there is anyone from the public. All right, moving forward, next we're going to go to the Office of Nurse and Workforce Report. Dr. Burks.
This is the ONW report. First, I'll start with the ONW Nurse Professional Fellowship. That was a fellowship that was done here at the board. We have 22 recipients that have graduated from that program. One scheduled to graduate in May. We have one person scheduled to graduate in August. And 8 of those recipients have completed their work service agreement because they had agreement to work either a year or 2 years in Mississippi. And 3 are scheduled to complete their work service agreement this year. And there's a chart, you can see the breakdown of the number of recipients and their dates of graduation. Also, with the ONW Nursing Scholarships, those funds were distributed, $860,000. We have a chart below that shows you the students' participation. It also breaks it down and shows you their programs that participated. We'll have a detailed report available in July 2025 once all of the data has been collected from the students. In addition, we have received letters of appreciation from Meridian Community College from their students, and the letters are attached as well. And I just want to share a couple of things from those letters. First, in the letter, it says, for the students, recognition as a milestone encourages them to improve their academic success and ease the financial burden associated with higher education today. So the foundation itself calls and they appreciate the board for those funds. And also you'll see that there is some information from the students themselves, and it gives you their name, what school. You notice they're from all over the state of Mississippi, but there are some that really stood out. One of the recipients, she's a true testament of that pathway. She started out as a CNA, she became LPN, and now she's in the associate degree nursing program. And that's one of the things that ONW really encourages is for individuals to think about that pathway. It don't matter where they start, it's important where they end. And so just her being that person that got started at that part of CNA, she's a testament and someone that can go back to her community and share what she's done. There's also 2 young ladies that are receiving funding that were also GED graduates. And sometimes we think that you know, a person don't have high school diploma, if they don't go to a certain school, that they are not down. And it just shows no matter where a person is, they can make success. So I applaud these students and I applaud Meridian for sending that information to us. Also, with the ONW Advisory Committee, we will have 4 members that's gonna roll off in June this year. And those members are listed on the report. And we do have a copy of the application, it is attached. And that application has been shared with our stakeholders. And it is also now uploaded onto the ONW website. We have also taken submissions for the spring edition of the newsletter. In terms of MVP, we currently have 29 nurses that were in conflict. One has been referred to legal. And we also had one person to graduate from the program in January of 2025. And as you can see, ONW has been used in the community, and there are some upcoming events that ONW will be participating in. And that is the end of the report for ONW.
Any questions for Dr. Burks in regards to ONW?
No questions, Madam President, but I do want to echo Meridian. I received that letter yesterday from Meridian Community College. And I walked it around, I read every testimony to those students and what Meridian's president sent, the letter, and that just shows the impact and the importance and the significance of the ONW scholarship monies for students to enhance the workforce here in Mississippi, because they took the time to sit down and write a testimony. It made such an impact on their lives. I did want to echo what Dr. Burks had said about that. They sent me an individual letter and then they sent me the whole packet. And I walk it around to Dr. Burks because I think it's important that the public understand the significance and the importance of continuing the ONW program.
And Dr. Burks, from me to you guys, I think that's a wonderful piece to add to this because it allows us to put a face with a name and the monies that we're spending to ensure our workforce. So thank you.
And Madam President, if I may add, as chair of the ONW committee, the ONW Advisory Committee will meet February 14th at 2 p.m. So we're looking forward to that as a committee.
Thank you.
Is there a way this could be added to our website so that others, the public could see this?
We talked about it with ONW adding it to their newsletter and their website. So ONW is working on some things to make that some other issues possible via the website and some other avenues.
Good for the public to see.
Yeah, absolutely. So thank you, Dr. Burks. That is greatly appreciated. The next thing we're going to move on to is the practical nursing education report. Dr. Burks.
From the practical nursing programs, the PM programs participate in MSBON on the report. And we have received a copy of that report, but we're in the process of reviewing for further analysis. And we will have a detailed report for you April 2025. Also, the programs in Mississippi, they are required to complete a Mississippi annual report that is in the standard. That report, the deadline, they did meet that deadline, and we'll have that finalized report also in April 2025. But there are some key program outcomes that I do want to share with you all in just reviewing that information. First is in the enrollment, because there has been documentation and evidence that enrollment has decreased in schools. But I just want to tell you that enrollment numbers have remained stable across institutions from 2015 until the present. In 2023-2024 academic year, they saw their highest first-time admissions across all institutions in Mississippi with a total of 1,240 students. The lowest within 2020 and 2021, with that being 1,014 students. Also, when you look at their graduation statistics, the graduation rates, it peaked during the 22-23 academic year. They had 804 graduates, and it marked an increase from the 21-22 academic year, where they only recorded 672 graduates. Also, when we look at their completion rates, the schools are able to establish their own completion rate, but they are facing some challenges with the student retention and their time rate of completion. Specifically, East Mississippi, they've had difficulty in meeting their established completion rates for both 2022 and 2023. But what they have done is they're now working with their student navigators to increase the completion rate. And we use these reports and tools because it can identify areas of improvement and it also can establish the benchmarks for future success. I have a report regarding Mississippi Gulf Coast College Apprenticeship Program. And as you all know, the board, you all approved and have the apprenticeship program. So with their first cohort, that was in May of 2022. That was completed September 2023. They had their second cohort that started in 23. They completed it in 24. They started their third cohort last May. And this group that they have currently, they're doing exceptionally well with their standardized tests. They've actually surpassed in terms of the percentages on their tests that of the first two cohorts, and they're now entering their term to their completion. With enrollment, cohort 1 started with 20 students, they completed with 14. Cohort 2 had 25, 20 completed, and for cohort 3, they admitted 25. We have their faculty listed. Those faculty members are credentialed. It's Lauren Mehart, Kim Hunt, and then the senior river staff, because the senior river staff has been frustrated, and these students getting that on-the-job training. When we look at their completion rates, and this information is what they were required to submit to the board when you all approve the program. For cohort 1, their completion rate was 70%, but their benchmark was 60%. Their pass rate on the NCLEX was 93%, their benchmark was 80%. Job placement rate was 100%, and their benchmark was 80%. For cohort 2, their completion rate is 80%. Their NCLEX pass rate is 90%, job placement rate is 100%. So they have exceeded their benchmarks and they are in a line or above what other schools in the state is doing in the traditional program. So that is just a testament to the apprenticeship programs, and hopefully in the future more schools and facilities will take interest in starting such a program. And looking at the PM programs NCLEX scores, I just want to share with you where Mississippi is in comparison to other programs. For January 2024 to December 2024, we had a total of 871 students who took the NCLEX. 787 achieved passing on the first right. So with Mississippi for the year of 2024, the pass rate was 90%, and for all other schools in the United States was 88.38%. Mississippi for the last 5 years have been above what the national average is. And that's just a testament to the schools, the faculty, the facilities, because the schools cannot do without the healthcare facilities. And we do appreciate their clinical partners because, again, they play a valuable part. Upcoming accreditation visits. I have East Mississippi. That visit is going to be April the 28th through the 30th. East Central is going to be May 21st to the 23rd. And the fall, Hines, Holmes, Jones, Pearl River, they will all have accreditation visits. And then there's a list of the participation from the PM department. And on the back, you'll see the apprentices. And it actually shows you the jobs they had prior to them being in the apprenticeship program and where they are practicing now as LPs. We have the cohort 1 and cohort 2. That is the end of my report.
Dr. Burks, thank you for your report, but I do want to reflect on one thing. You made the comment that it's a testament to our school systems here in Mississippi that has reflected our pass rates. But I would also include you in that group as well, because under your leadership, we've continued to thrive. So thank you as well, Dr. Burks. That being said, would anyone like to make a motion to accept the practical nursing education report?
Make that motion.
All those in favor say aye.
Aye.
All right, next we're going to move on to the executive director's report. Dr. Johnson.
Good morning, Madam President, members of the board. A few points to discuss, to bring to your attention on the mid-year meeting. It's March 11th through 13th, 2025. And all board members should have their accommodations that have been approved to attend that particular meeting. The Board of Nursing Board Retreat will be held at the Sheraton Refuge Hotel in Flowood, May 12th through 14th, 2025. Please mark your calendars. You'll be coming in on the 12th for that afternoon reception, probably that evening. There's more to come on the agenda. And it will be a day and a half of educational presentations for the board members. I do want to bring to your attention the Operation Nightingale. When we look at the updates, I received correspondence from the FBI this past week and from the Department of Health and Human Services, which include an affidavit related to the MetLife Institute doing business as MetLife Institute, Naples, Florida. As you are aware, this remains an ongoing investigation. And this was one of the schools that was being investigated, but now they have completed an investigation and received the affidavits. They were notified, nurses was notified that 4,531 licenses are affected by this school, a fraudulent license, which means 1,653 individuals across 50 nursing regulatory boards. The investigation remains an ongoing investigation, but our database revealed that initially we had one licensee who may be impacted. I received additional information yesterday afternoon prior to leaving my office that we have 4 nurses that may be impacted. The affidavit received stated that anybody that graduates from this school after a certain date, they are fraudulent. That's a signed affidavit. And so we have an investigation. We have done our due diligence. The licensure division, and I applaud my licensure staff as well as all my staff in working with me on that. And we have looked at the 4 individuals. 3 individuals did not renew their, 2 did not renew their licenses. 3. So they are inactive. They don't have a license in the state of Mississippi. However, what we have done is we flagged them in our nurses database, which is the national database, in accordance with what the FBI has required us to do. That says warning FBI investigation. So if they apply in any state or try to get a license in another state, even though they're not one of our licensees, that warning will come up. And those boards are notified then to do their due diligence in not allowing that to happen and do further investigation. So right now, really one that is actively licensed in our state that may be impacted by the FBI. And additionally, I want to talk about, you can see the board is always visible, very visible, but I want to talk about the regulations. Basically, they have gone into effect. Part 2825 on Monday, December 2nd, we met with the OLRC 2024 regarding the proposed changes to this involving the appeals process. The change was approved. We are waiting on the resolution from OLRC. And once we receive that, there's a 30-day waiting period before the rule change is effective. Part 2840 on January 22nd, 2025, we filed with OLRC the proposed changes to Rule 1.5 regarding prescribing for weight loss. The temporary emergency rule was effective January 30th, 2025. It is effective for 120 days, at which time if the OLRC has not acted on it to make it permanent, it can be renewed for an additional 90 days, which gives a total of 7 months approximately, in order for the OLRC to make a final ruling on that. That has been posted, I believe, to our website, as well as on any other, I think our decision tree and all other information out there to make them aware of that. Additionally, Part 2870 was also filed on January 22nd, 2025 with OLRC, and this is Rule 1.1, which defines gratuitous nursing. Part 2810 was filed on the same date. This proposed change is to Rule 1.12, which attempts to clarify the qualifications and timeframes regarding initial applicants for licensure. And that's they can take the NCLEX, they have 2 years, 6 times to take it within 2 years of graduation date. And I believe additionally, that's all I have. I have a short report today. I do want to recognize my staff, as I always do, for the hard work they do. Someone mentioned about the magazine. When Miss Vanessa left, I inherited the magazine. I am the editor of the magazine. But as was mentioned earlier, that magazine cannot go forward without the input from the staff as well as the board members when we solicit your input. I just go over it with a fine tooth comb, and the publisher has to deal with me. So we got a good working relationship. It is an effort of love, but it is a lot of hard work. And I would just like to commend the staff as well as the board, because the recognition received today is also recognition of the hard work of the board of nursing staff, in addition to the board members for the hard work that they do. So thank you. It is an honor to receive that. And I was surprised, but the library commission was extremely excited, and they all wanted to be here today, but she said they had something to come up to do that. So thank you all for your leadership. And that's all I have, Madam President. Oh, I got 2 new staff. I sure do. I don't have 2 new staff, but we have 2 new staff here at the Board of Nursing. And Dr. Cagle, they're in your division. If you don't mind, would you introduce those 2 individuals?
Oh, very happy to. I've been ecstatic always. So we have 2 new additions to the APRN department. We have Queen Denise Daniels, she will be one of the APRN investigators. So she and Floyd will be the APRN investigative team. So after more than a decade, Floyd has some help now. And so he's getting oriented, starting just this week. I said, there's not a better week to start. You get to meet the board, you get to see what hearings look like. And so she's been here. And then we have also in the APRN department, a 3rd licensing officer. So with the, she will help both Kalisha and Joanna with the licensing of both the undergraduate and the graduate advanced practice. And also she got to start at a good time. We're not in the licensing cycle, so she can kind of catch her breath before that hits, because it's just kind of all on once licensing starts. So we're grateful to have both of them here starting this week, getting them kind of oriented, and welcome to the board.
Welcome. Thank you.
Welcome, ladies. Thank you, Dr. Johnson.
Yeah, one
Yes.
question, Dr. Johnson. Going back to the Operation Nightingale,
Mhm.
you said there was one person that had sort of an active life. What is that, or is that person able to practice now, or they're under some suspension, or what, how does that work?
But it's an ongoing investigation, but I will say this. Once the FBI notifies the nursing regulatory body, then the nursing regulatory body has the authority to follow whatever process they have in place to address those issues. Usually it's summary suspension. That's something of an emergent nature. And so that in that particular licensee would not be able to practice until they come before the full board from the point that that is instituted. So that has been instituted.
Any other questions for Dr. Johnson? Thank you, Dr. Johnson. Next, we're gonna move on to board business. First is the request for approval of the business meeting minutes for December 6th, 2024. Is there a motion? Do I have a first? And all those in favor? Aye. Request for approval of agreed settlement proposal minutes, December 2024. Do I have a motion?
Make the motion.
Okay. I'll defer to Ms. Moody, my esteemed colleague.
All those in favor say aye. Next is request for approval of hearing panel minutes, October 2024. Do I have a motion?
Motion for approval.
Do I have a second?
I'll second.
All those in favor say aye. All right, the next thing we have is future meeting dates. So we have the administrative hearings and settlements that will be April 7th, 8th, 9th, and 10th at 8:30 a.m. We will have the business meeting on April the 11th, 2025 at 11:05 a.m. And the hearing panel for that cycle will be Jeremy Cummins, Nancy Norris Johnson, Mary Stewart, and Miss Janelle Walker. Right. Janelle Moody. So we need to make an amendment to that. Or just a typo, make a correction on it, sorry. All right. Next is the committee reports and, what we will start off with first is the executive committee. And in the executive committee, I do have a motion to bring out for the board members. On that, I would like to reinstate advisory opinions. Advisory opinions and to have the practice committee explore needed advisory opinions so that we can release those. Do I have a second on that?
I'll second.
Okay. With that being said, do we have any discussion?
Madam President, will you help me understand that language?
Yes.
Right, me? Yes, ma'am.
So if you recall, we used to have opinions or position statements on the
Okay.
Board of Nursing website.
Yes.
But then we pulled them back to use strictly the decision-making model,
Yes.
okay, the decision tree. Well, what we've had some discussion and have decided that we would like to reinstate those advisory opinions in coordination with still the decision-making model.
Okay, thank you.
You're welcome.
So those advisory opinions, were they issued based on a subject, inquiries that were coming to the board, or did the board on its own motion decide that this is an area we need to address and put some statement out about? How was that?
I think it, in my opinion, it came from both areas. Concerns on some things we've seen, but also we do get quite a few numbers of calls. And I think by having these, it would also help the staff with the influx of calls that are coming in.
Another question, do you, my concern is you would pigeonhole yourself into an opinion prematurely if you had someone come before you about any of those, anything that you issued an opinion on. If there's a case that comes forward that falls under that opinion, you've already stated what the board says. I worry that you pigeonholed yourself into a stance.
So we had that discussion. And so do you want to kind of elaborate on that for me?
The discussion would be the advisory opinion would be that it would just be informational only. It's not a legal opinion. It does not apply to case facts. It would be applying the scope of practice, the Practice Act. It would not embellish over that, but it would be an opinion to give someone a reference point. If the board is getting a lot of calls about a certain thing, this is where you would need to look to the Nurse Practice Act. It would cite the applicable law.
So would it be like a frequently asked question thing, or just blanket statements of opinions?
That is the intention.
And from my understanding, there are disclaimers that clearly
Yes.
state that it is not.
It's not a legal advice. Yes, ma'am, Dr. Johnson.
If I may, Madam Chair, it's really position statements. Basically, you can have a position statement or an advisory opinion. Some boards have advisory opinions, some have position statements. The board had quite a few position statements for those of you that are new to the board in the past. And the board, the full board at that time made a decision. They did not want to go with those have all those position statements up there. There are some frequently asked questions that address some of the issues to address Mr. Castillo's question that he asked, and it's usually based on the number of issues that come into the board on a specific topic. It has to be evidence-based research. It can't be, I'm just thinking up something to put on a position statement. It has to be evidence-based research to support what's in the position statement. It has to follow the standard of practice for the specific issue that's addressed, and it gives references to that. So basically, that I just want to give that information to you because some of the board members are new and may not know that we've had those position statements in the past, but the full board at that time did not want to go with that route because they're not defensible. Rule and regulation, Nurse Practice Act is, and I think that's what the AG rep was basically saying. So there would be a disclaimer on any of those about this is not a legal document, just guidance for those individuals that the board is receiving a lot of practice issues about. If that makes it a little bit clearer for you.
Yeah, I can see how that would be helpful for guidance.
I think the decision tree is very helpful in most circumstances, but I have had people reach out and say, I use the decision tree and I'm still in a quandary here. So I think that's a wise move because we're currently revising our position statements and they're valued and they're utilized often from conversations I have with nurses in our state. So, okay, thank you.
Any other questions? All right, so we're going to take it to a vote. All those in favor say aye.
We have a second.
We did, Jeremy.
Aye.
Any opposed? All right, it will carry. Next, we're going to move on to the Compliance Committee.
Madam President, I have one. I move that the board adopts the compliance committee recommendation that we accept 3 compliance affidavits. One, that we accept a 180-day extension for R 649848 to complete her reorientation to nursing course. And the second one, that we accept a 14-month extension for probation for R 868727 R 905135 MP.
So Nancy has made the motion. Do we have a second?
A second.
Any discussion? All those in favor say aye. Do you have any other business? Thank you. Next, we have the Advanced Practice Committee. Dr. Stewart was doing that, or she's not here today. Beverly, were you filling in for?
Yes, no report.
Next, we have the Practice Committee. Ms. Moody, do you have anything coming from there?
Yes, thank you. The practice committee met on December 6th to discuss the administration of ketamine to patients with depression. And it was determined that it's not within the registered nurse's scope of practice to administer ketamine for the treatment of depression. So we based this off of lack of FDA approval, insufficient long-term data, limited evidence-based research, and concerns about standalone ketamine clinics. And as Dr. Gentry stated before, we're working through the position statements.
Okay, so Ms. Moody has made a motion. Do I have a second?
Second.
Any discussion? All those in favor say aye.
I would like to commend Ms. Moody on her excellent leadership of this committee. She is moving forward in a timely manner and keeping us on script, and I am grateful for that. It is needed to be done, and I'm thankful that you have taken charge. So
Thank you so
we are
much.
grateful for you.
Thank you.
Thank you, Ms. Moody. Do you have any other business from your committee? Do you have any other business from your committee, ma'am?
That's it. Thank you.
You're welcome. Next, we're going to move on to Administrative Code Committee.
Yes, thank you. So the Administrative Code Committee met on Friday, January 17th, 2025, and discussed potential amendments to Part 2840, Rule 1, which deals with the prescribing of medication for weight loss. The committee reviewed several options and decided on a version. The rule that ensures that the needs of patients are met while still achieving the board's duty of protecting the public. The amendment was approved by full board on January 21, 2025, and became effective as an emergency rule on January 30th, 2025, as the executive director formally stated. And the committee also discussed the matter of delegating medication administration to unlicensed personnel. However, it was determined this issue was beyond the authority of the committee as it is a statutory matter. That's all we had come out of our committee.
But you're not bringing anything forward today.
No, ma'am, just our report.
Thank you. Thank you. I greatly appreciate your hard work. You work really hard with that committee, so thank you. The next committee is the Finance Committee. Mr. Cummings.
You have a report, and you can find in your packet, financial report as well as the fiscal year 26 budget handout that Dr. Johnson used when she defended our budget before the legislature. Fiscal year 25 revenue collected through December was $5,687,915. A lot of that, or the majority of that's due to being RN renewal years. So that's where we get the majority of our revenue. The trend continues to increase for our revenue. We're up 1.5% from this same period last year. So that's a good thing. As far as expenditure, salary expenses continue to be capped by the legislature. Current expenses are well below budget amounts due to open positions. We are actively recruiting for those positions and have been given authority to advertise and hire those positions at rates above the starting salaries. Travel expenses were much lower in the current month than they were in the previous year. Commodity and supply expenses are much lower this year than they were in the last 2 years, and that would be due to a change of vendors. So that's a good thing there. O&W grants, as been stated earlier, totaling $860,000 have been released to the different nursing programs throughout the state, and that took place in the month of September. This represents roughly 86% of the O&W grants dispersed, and there have been no further grants paid since then. In other matters, as stated earlier, you've got the handout. Dr. Johnson presented the fiscal year 26 budget to the House and Senate in January. The largest change presented, there are two. One would be salary increases were requested at 3% to all staff members, 5% increase to nursing positions, and then also a request to add $500,000 to O&W grant money. Current available cash as of 12/31/24 was $9,656,804.13. For our newer board members, let me remind you that that is a very large amount, but it kind of carries us for a 2-year term because of our much lower amount of LPNs. 25 will be an LPN renewal year. So we have to have a carryover to continue what we have. So when we see this number, let's not get excited because it does have to carry us for a two fiscal year period with the exception of the revenue we'll bring in from LPNs. That amounts ample money to sustain the full function of the board. That's my report.
All right. So thank you, Mr. Cummins. Would anyone like to make a motion to accept the finance report?
I'll make a motion, we accept the financial report.
I'll second.
Any discussion? All those in favor say aye. Oh, wait, okay, we'll move forward. Next, we have the Office of Nursing Workforce Committee. Once again, Ms. Gentry.
Got a little ahead of myself, my apologies. So I was just so excited when I came behind Dr. Burks and grateful for her and her leadership. The advisory committee for O&W will meet Valentine's Day, February 14th at 2 p.m. as previously stated, and discuss some of their insight and wisdom into O&W and all things related. So
thank you. Yes. Anything else? All right. Next, we have the Legislative Committee, Ms. Clanton.
We pretty much covered it. I have nothing to bring out at this time for that, but we kind of covered it with Trey's presentation. So we're continuing to watch to the end of session.
Thank you, Ms. Clanton. Any other business today before we prepare to adjourn? All right. Would anyone like to make a motion to adjourn? So I've got a motion by Jeremy, second by Beverly. All those in favor? And we are adjourned. Welcome to the Mississippi Board of Nursing. Before we begin, I'm going to ask Ms. Johnson to lead us in prayer.
Now, Lord, we thank you, God, today. Thank you for the sunshine. Thank you, God, for allowing us to be here. Lord, I ask you, God, to help us make the right decision today. In Jesus' name, amen.
Thank you. So today, the board is made up of 13 members, 7 RNs, 4 LPNs, 1 physician, and 1 consumer. Today, we are a full board panel, with the exception of the 2 that were recused from this. At this time, I'm going to start to my left. If each board member can state their name for the record.
Drew Calhoun.
Alvino Castillo.
Janelle Moody.
Sandra Culpepper.
Janie Clanton.
Lacey Gentry.
Dr. Renee Dotson.
Nancy Norris Johnson.
And at this time, I would like to turn it over to the Assistant Attorney General, Ms. Pamela Ratliff.
Good afternoon. My name is Pamela Ratliff. I am the Special Assistant Attorney General for the AG's office, and I will serve as the hearing officer today in the 2 appeals pending before the full board. Cause number, Hobgood first. It will be cause number 2021-0192 and 018-0008 in the matter of Carol Jean Irwin Hobgood versus Mississippi Board of Nursing, license number R-67410-NP. For the record, I know you just introduced yourself, but I'm going to ask for the record if the board members will introduce themselves again.
Drew Calhoun.
Alvino Castillo.
Janelle Moody.
Sandra Culpepper.
Janie Clanton.
Lacey Gentry.
Dr. Renee Dotson.
Nancy Norris Johnson.
Okay, thank you. Would the attorneys for the appellant introduce themselves?
My name is Doug Mercier, the attorney for Ms. Hobgood, the appellant.
And attorney for the appellee?
Brandon Walker.
This appeal is in accordance with Code 75-1531. 9, the appeal is to the full membership of the board and is limited to the record of the hearing before the board hearings panel. The full membership of the board may not retry the appealed case. Argument should be directed solely to the issues from the record on appeal and shall not include new evidence, testimony, or witnesses. Appellant and appellee are allotted 20 minutes each to present arguments as to why the decision of the board should be overturned or affirmed. Would the appellant like to reserve time?
Yeah, if I could reserve 8 minutes.
And I was asked, a member of the board, would you mind being my timekeeper?
Yes.
Okay, thank you. Anything before we begin?
No, you're not.
Mr. Appellant may begin.
Good afternoon, Madam Hearing Officer and ladies and gentlemen of the board. Ms. Hobgood's appeal is not to say that she is innocent of all the charges. Ms. Hobgood's appeal is to say that she is guilty of the documentation charge, which is charge 2. But based on the record, the testimony and the exhibits that were presented at the hearing, she is not guilty of charges 1, 3, 4, 5, or 6, based upon the record. There was a decision handed down on October 5th, 2023, and it was invited in a final order dated January 18th, 2024, and that's what we are appealing. The original complaint made against Carol Hobgood was dated June 16, 2023, and it made those separate charges we just mentioned against her. It pertained to encounters during 2016 forward through, I believe, 2020, 2021. The charges, I just like to make sure that we'll understand which ones we're talking about. I'm not going to try to read all of them, but charge 1 was the general charge of practicing nursing failed to meet generally accepted standards of such nursing practice. Charge 2 was that respondent falsified or repeated in a negative manner made incorrect entry for government. charge 3, that says that it was, negligent or willful acts inconsistent with the health or safety of the person who's under licensed care. Charge 4 was the charge of failure to act appropriately in safeguarding the patient from incompetent healthcare practice or practitioner. Charge 5 was that the respondent engaged in professional conduct by inappropriately prescribing controlled substances by an advanced practice registered nurse. Charge 6 was that respondent falsified or repeated negative manner made incorrect entries or failed to make essential entries on records, which is essentially the same as charge 2. The standard for the proof that has to be provided is, I don't think, in dispute based upon the briefs of the two parties. The proof that's required to be presented to the hearing panel, which they must base the decision on, is clear and convincing evidence. And it must be clear and convincing evidence that is substantial evidence. The quantity is substantial evidence. It's not the same as clear and convincing evidence in a criminal trial. It's not the same as preponderance evidence in a civil trial. But nevertheless, it has to be substantial and clear and convincing evidence presented in the record. Suspicions are not enough. It's got to be in the record. And here we have some things in the record that support the charge that Ms. Hobgood admitted to, which is charge 2. But for the others, our position is the record is absent of what is needed. In addition to the proof that's needed, sometimes cases take on a flavor where it seems like the records I read, the board members, the panel is looking for the nurse to present proof of her innocence, but that's not what's required. It's the board staff's requirement to prove the guilt of the licensee. The licensee is presumed innocent, and the board staff has to present evidence at the record through the form of testimony and exhibits to actually prove the guilt, very convincing evidence. It's not merely a suspicion, but it has to be more than scintilla. It has to be substantial evidence. Here, I think it's important what Ms. Hobgood admitted to, and I'm going to read from the record briefly. Just her response. That is on page 31 and 36 of the transcript. Exhibit C, pages 11 and 12, and there's another exhibit C, they're both the same thing, the transcripts, page 31, 36. This is how she testified. Ms. Hobgood, okay, so the first patient 1, was a young male that experienced an automobile accident in 2017, had no insurance, and I was at that time seeing his dad and mom. And this patient came in with significant pain. He was unable to go to pain management. We live in a rural area in Tylertown. So I picked that up. And yes, he was prescribed pain medication on a monthly basis from 2017 through 20 or 17 or 18 through 22, I believe, or late 21, at which time he was able to get insurance and was referred to pain management. Patient 2 was a relative of his, and yes, she did also receive pain medication. It's not uncommon for the 22 prescriptions over a 2-year period. Normally that would be 24 on a monthly basis. Their dad, who I also saw, came in 21, 19, 21. We were not e-prescribing at that time. The prescriptions were printed and they were picked up on the same day. In 2020, we were in COVID. Our clinic was a drive-up COVID testing clinic. So no, there were not a lot of encounters in that year because we were more in the basically parking lot, and our clinic was shut down, but we were trying to accommodate our patients with their prescriptions. And that lingered into early 21. Patient 1 was also seeing a neurosurgeon in Louisiana where he was getting every 3-month rhizotomies or nerve burning procedures. Patient 2 was seeing an orthopedic in Hattiesburg for the complications that she was being prescribed the medication for. Basically, if I'm guilty of anything in 2020, it's lack of documentation. Little explanation. This is a family. She was treating the the mother, the father, and the son. The son had had a severe automobile accident in 2017, I believe it was, and he continued to have pain, severe pain, which he received treatment from both her locally in Tylertown and from a physician, a neurosurgeon in New Orleans. The mother had rheumatoid arthritis, and she was being treated by another provider as well. So yes, she was in Tylertown. She was a local provider providing. And then the father, I think we'll see in the record, he did not receive, he had some chronic issues, but he was not receiving pain medication, if I'm not mistaken. I've got it marked in the record. Now, during the hearing, you had the testimony of essentially two people. You had Ms. Hobgood, and then you had Dr. Cagle. And in Dr. Cagle's testimony, it did not support the charges for charge 1, 3, 4, 5, or 6. It did support the charges for charge 2. What Ms. Cagle said, Dr. Cagle, excuse me, what she said was, this is on page 18 of the transcript. She's being asked a question by the board's attorney, I believe it's Mr. Walker. Question, instead of looking under field, look under written. Answer, on May 29th of 2021, both were written. They were filled on different days, but they were written on the same day. On May 3rd, 2021, they were both written on the same day, but filled a couple of days separate. So you answer, there were several written on the same day, and then they may or may not have actually picked them up on the same day. Question, so in your experience, is this normal or is this somewhat unusual? Can you speak to that? Well, answer, well, it's certainly a lot of medicine in the house on the same day. Perhaps they could have written together being family members. They didn't always fill them on the same day. It's interesting. It's not necessarily a usual thing when you see that many, 22 over that period of time. So Ms. Cagle's testimony there was not that there was a violation of the standard of care. She said it was unusual. She said they were a family member. They could have written together, which of course is what Ms. Hobgood testified that they did. She also testified that she would write the scripts in such a manner that they could get them filled or picked up, excuse me, the father could pick up the son's prescriptions when he came because he was on the pickup list. Dr. Cagle continued, it was a question to her on page 20 at the bottom. So in practice, when someone is on pain meds, do you generally do something to see if you can get them off of pain meds, or is that a case-by-case basis? Her response was, it is a case-by-case basis. And then down at the end of that response, she says, but there are people that are truly just on pain medicines each month because that's all at the time would help them. Regarding the dosage of medication that was given to the son, on page 22 of the transcript, Dr. Cagle was asked questions about that. There it says, the question is, let's go to the last, well, let me ask you this. I'm looking at what we have in his record in the PMP. Was that, you kind of said per household, but did he receive for that one patient in particular, the son, I believe, was that a high amount of pain medication to be receiving overall? He did receive 90 tablets every month, every 8 hours, every day. That's a good dose. He was pretty young. Dr. Cagle also addressed another matter. The question is, did you see times in there where he presented for sinus issues? And I believe for the board that's referring to the father, he seemed to have a lot of sinus issues at one time in particular. He had abdominal pain, and that was a significant pain episode. Question, when you presented with sinus issues, did you see anything in those records any times when you prescribed pain medications on those visits to the pain center? A lot of times they would coincide, and he would get medicine for sinus and medicine for pain or medicine for his abdomen. I'm mistaken, that was the son. So what you had here was a family in Tylertown
a rural area, being treated by Dr. Hobgood. She was a family nurse practitioner. Two of them had other physicians that were treating them. The sons are being treated in Louisiana for severe injuries, pain that he continued to have. The mother had other treatment she received for her rheumatoid arthritis.
That's fine. Happily.
Thank you, Your Honor. I'm not gonna I was gonna originally rehash go back into the charges, but Mr. Mercier named all the charges that were brought against Ms. Hobgood. I'll just briefly touch on the evidence. There was evidence that was submitted that these included medical records for patients. It showed the prescriptions, also as Mr. Mercier touched on. As he's already said, Dr. Cagle gave testimony regarding the prescriptions and the standard practice when prescribing controlled substances are prescribed. And when the board rested its case, the appellant was given the opportunity to cross-examine Dr. Cagle. And when the appellant was asked by the hearing officer if she had any questions, the last thing she said was, "No, but it makes me feel incompetent." I want to emphasize, and Mr. Mercier has touched on this as well, but at that time, it was clear and convincing evidence. That's what had to be, that was the burden that the board had to meet. All you're looking for today is substantial evidence. And in looking at that, your four basis for overturning the decision of the panel is, was it supported by substantial evidence? Was it arbitrary or capricious? Was that decision that the board made beyond the agency of the power, or the power of the agency, excuse me? Or did it violate some constitutional or constitutional right? Mr. Mercier has read some of the testimony that was given, but not all of it. Dr. Cagle testified that the PMP for patient JJ at the time revealed that she was not the only provider that was prescribing hydrocodone to the patient. That PMP indicated that there was also another provider that was prescribing controlled substances to that patient, often less than 30 days apart. And she was asked if this was a common practice. She said it really should not be if you're checking the PMP, excuse me, and able to know that it's being filled already 8 days prior to something. It goes on to say when it's a 30-day prescription with 90 tablets. In looking at that PMP, it sometimes showed that that patient was receiving hydrocodone and oxycodone prescriptions that contained 60 and 90 pills, just days apart from when Ms. Hobgood had prescribed. There's also evidence in the record that she had knowledge of those prescriptions, that she had been prescribing from, I think, 2019 to 2021. It's in the record. And she knew that another provider was prescribing those as well. She admitted that in the hearing when she was asked if she was aware if he was receiving some pain medication from another provider. The regulations that in 2840 that deal with prescribing controlled substances require that you look at the PMP, a prescriber look at the PMP. It specifically states the APRN shall utilize the MPMP at each patient encounter which an opioid prescription is ordered. You could clearly look at the patient's PMP in the record and see that he was being prescribed in some months at least 150 pain pills. What she gave as her reasoning at the hearing was that she was just trying to help because he didn't have insurance. So see, Mr. Mercier said they lived in a rural area. She was trying to help. But you could see if she had been checking the PMP, she testified that she was, that she would clearly see, number one, that how much pain medication was being prescribed. And number two, it also showed that that patient was getting insurance paid for on some of those prescriptions. Which either means she wasn't checking the PMP as she was required to. She was prescribing also on top of the other prescriber and didn't know that he had insurance. This means that she was prescribing in a manner inconsistent with the health and safety of a person under her care. Also means she failed to meet the practice of nursing in a manner that meets generally accepted standards. And because she was inappropriately prescribing controlled substances. That's literally what the code says. And on more than one occasion in her hearing, she said she felt incompetent. I mean, if you were to buy her argument that she was checking the PNP, she testified she knew he was receiving pain medication from another provider, but even if knowing that, she was continually prescribing medication on top of medication. That's even more concerning. And like I said, at the end, she said that makes her feel incompetent after the testimony was over and the evidence was presented. The evidence today, I'm sorry, not today, the evidence that was presented at the hearing also stated, and I don't really think this is up for dispute because Mr. Mercier alluded to this, that their position is that she wasn't documenting correctly, and she admitted to that. There was oftentimes the patient would present for sinus issues, and there would be a prescription for hydrocodone or oxycodone. And there was nothing to document why that was administered. I'm sorry, why that was prescribed. She was knowingly prescribing pain medication to a patient she knew was receiving pain prescriptions from another provider. Like I said, this was often days apart. And the only explanation was that she was trying to help that patient. That's clearly inappropriately prescribing, which doesn't meet the standard of care and is not putting that patient at risk to somebody who's under her care. So those all go to show why there was clear and convincing evidence, because she admitted she was knowingly prescribing. She admitted she didn't document. She admitted that the evidence made her feel incompetent. And the Mississippi Court of Appeals has previously found that a party's own admission is supportive of a clear and convincing standard. Now, if somebody's saying they're incompetent, they felt incompetent after hearing their case, it's a pretty good indication that they felt like they were guilty of what was charged. The Mississippi Supreme Court has defined substantial evidence as evidence that a reasonable person would accept as adequate to support a conclusion. That's what y'all are looking at today. So without question, those charges were supported by the evidence. There's briefly touched on in the brief, the appellant argues that this was disproportionate because the decision was disproportionate because there was no patient harm. She wasn't charged with causing patient harm. And furthermore, there's nothing in the rules or anywhere that says if you cause patient harm, you get X. That's and nowhere does it state that. It states specifically in 73-15-29-2, when the board finds any person unqualified because of any of the grounds set forth in subsection 1 of this section, it may enter an order imposing one or more of the following penalties. And those are all listed. I'm not going to go into that. But nowhere does it say that in order for patient harm to occur, or if it occurs, this is the discipline disorder. Second, the record was there's all kind of evidence proving that the appellant was guilty of the charges, saying that because another argument was that there's nothing that's shown in the record that these were medically proper, I believe, were the words. The evidence was submitted without objection, displayed the amount of pain medications that she was receiving. The patient was receiving days apart. She testified she knew the patient was receiving the pain medication from another prescriber. And Dr. Cagle even testified the prescribing practices of appellant were very unusual and not in line with the standard nursing or regulations regarding the prescribing of controlled substances. Clearly, this was not arbitrary and capricious. The board acted within its authority. And for all these reasons I've stated, the panel, the full board should affirm the decision of the panel. Thank you.
Mercier, you have 8 minutes.
Thank you. Ms. Hobgood was not represented by counsel when she was here before the board, and I've seen many nurses here before the board feel incompetent when they are presented argument and evidence and question by board counsel. That's not that unusual. That's not an admission of guilt. Mr. Walker has said in his brief, and he has said here today, that Dr. Cagle testified that what Ms. Hobgood did was a breach of the standard or violation of the standard of care. I looked and I did not find anywhere where she said that. What she said was it was not common. She didn't say it violated the standard. That evidence is not in the record. Once again, she does not dispute the fact that the documentation was in error. Now, that arose from primarily when she gave her, well, let me back up. Let me say that this is an isolated incident over her career. This occurred, as we said, pre-COVID and during COVID. There's nothing in her record, her nursing record, or in this record that indicates that she's been a problem nurse practitioner before this board ever before. I think sometimes we forget how difficult things were in COVID and the accommodations that everybody made during that period of time. I'm sure everybody on this board made some accommodations in the way they conducted their life and their business, the career. I'm not saying it justifies things that were wrong, but sometimes things were done a little differently with the good intent of taking care of your patients. The physician that was treating the son and prescribing opioids also checks the PMP. So it wasn't just a one-sided thing where, as the board counsel alleges, Ms. Hobgood was not checking the PMP, or she did, and she prescribed in derogation of what it said, but the physician for the patient was prescribing as well. They were both prescribing, and it's up to the physician to determine whether or not his patient needs additional medication over and above what Ms. Hobgood was prescribing. So that's a double-edged sword. As far as the prescriptions being written at the same time, I think Ms. Hobgood gives a good explanation of that on page 31 of the transcript. They were writing together, as I've already mentioned. And she was asked directly, okay, so at any point were you checking the PMPs for either of these two patients? Her answer was yes, sir. And so the next follow-up question was, and you are aware that one patient in particular was receiving pain meds from another? Answer, I did. And as I mentioned, it was delayed. I did not see it was within a 3 to 5 day time frame. Now, I would have to go back to look. It was in the summer of 20 when I saw it. The first two were on there. And that's when we had a discussion that you either have to get the pain medicine from them or us. I do not recollect the second. I see 4 prescriptions on there today. I do not recollect the second one. So Ms. Hobgood was checking the PMP. She was having discussions with her patient about the medications that were being received from the other provider and her. And she took steps to remedy the situation. In summary, although there is evidence that in admissions, she was very honest. If you read, she was honest and she said she did not document properly, but she denies the other charges. Yes, she felt incompetent. I think anybody would if they're not represented by counsel and they're overwhelmed with argument. But attorneys know how to craft arguments and questions. And that's something she said, but it was not an admission of guilt. If you read the record, that's not how it was said. Based upon the lack of evidence supporting the other charges, especially expert evidence from Dr. Cagle, and I would request that you read Dr. Cagle's testimony for yourself and see what she said. We don't believe that the other charges other than charge number 2 were supported by substantial, clear and convincing evidence, only by suspicions. So we ask that you would modify the order of the hearing panel. Thank you.
I'll ask the board members have any questions to either party.
Mr. Mercier, you mentioned, Ms. Hopgood took steps to remedy the situation. On the same day, she wrote 5 prescriptions for narcotics. Help me understand how remedying a situation and writing 5 prescriptions for narcotics on the same day are congruent.
I don't know what day you're referring to. I was referring to her testimony where she addressed with her patient that he needed to either get in pain medicine, or excuse me, get the medications from pain medicine or from them, one of the two.
Did you not also say that she provided him with 5 prescriptions on that same day?
No, that's not what I see. What I'm reading here, it says, I do not recollect the second. I see 4 prescriptions on there today. She didn't say the same day.
Okay, what page are you on? My apologies.
I'm on page 32 of the transcript.
Okay.
I do not recollect the second 2.
So what I'm reading is she provided 4 prescriptions on that day. And then she put the onus on the patient to take steps to remedy the situation.
I don't read it that way.
Okay.
Because what I read it was they were discussing the PMP in general. But I'm not disputing you. It could be that way. That's not what I read. I wasn't here for that.
I'll just remind the board that this appeal is limited to the record that's before you. No new evidence or testimony can be considered, simply the record. And their argument is just their position to why it should be affirmed or overturned. Any additional questions?
I think I have a question. Could I draw your attention to page 5 of the board's brief?
Yes, sir.
Excuse me, first 4 paragraphs there, where it's stated that appellant admitted as much, well, evidence clearly shows that appellant had been prescribing hydrocodone, knowing that another provider was prescribing pain medication. Well, then it goes on to talk about, but specifically, there's a reference there to where it says specifically in section A, it says that APRN shall utilize the 1 PMP at each patient encounter in which an opioid prescription is ordered. And then goes on to say, without question, one can look at the PMP for that patient and see the patient was receiving at least 150 pain pills per month. How do you address that assertion on the part of the board?
Well, I can if he was receiving 150 pain pills, he was, but I don't know how many he was receiving from Ms. Hobgood and how many he was receiving from the physician. But as I stated earlier, if the physician is checking the PMP, which physicians check as well, are supposed to, opioids are prescribed, he may have determined that based upon the complaints for the patient, what Ms. Hobgood was prescribing wasn't doing enough. So he needed a supplement.
Any further questions? Okay, hearing no further questions, this will conclude the hearing in the matter at this time. I will entertain a motion for the board to go into closed session to determine whether the board needs to go into executive session.
I'll make that motion.
I'll second.
All in favor? Any opposed? All right, hearing none, motion carries. We'll now entertain a motion to go into executive session for purposes of deliberations on the matter of Policy number 2021-0192 and 2018-0008. So, Johnson, do I get a second? I'll second. All in favor? Any opposed? Board is now in executive closed session. concludes the hearing in this matter.
Yeah, we need Beverly. Again, we're gonna start to my left by doing a roll call.
Drew Calhoun.
Alvino Castillo.
Beverly Oliver.
Sandra Culpepper.
Janie Clanton. Lacey Gentry.
Dr. Renee Dotson.
Nancy Norris Johnson.
At this time, I'm gonna turn it over to the Assistant Attorney General.
Good afternoon. We're back on the record. Today is February the 7th, 2025. It is now 2 p.m. My name is Pamela Ratliff. I am the Special Assistant Attorney General with the Attorney General's Office, and I'll serve as a hearing officer today in this appeal before the full board in the matter of cause number 2024-0306 in the matter of Connie Jean McKnight versus UP Board of Nursing, license number R-796372. I know the board just introduced themselves, but I'll have them for the record introduce themselves as for the record.
Drew Calhoun.
Alvino Castillo.
Beverly Oliver.
Sandra Culpepper.
Janie Clanton. Lacey Gentry.
Dr. Renee Dotson.
I'm gonna have the attorneys represent themselves for the record.
Doug Mercier, attorney for the appellate Connie McKnight.
Brandon Walker.
This appeal is in accordance with Mississippi Code annotated 73-1531-9. The appeals to the full membership of the board and is limited to the record of the hearing before the board hearing panel. Full membership of the board may not retry the appeal case. Argument should be directed solely to the issues from the record on appeal and shall not include new evidence, testimony, or witnesses. Mr. Mercier, would you like to reserve time for rebuttal?
Same 8 minutes.
Each side will have 20 minutes for arguments to present why to the board, why they believe that the board's hearing panel's decision should be affirmed or overturned. Mr. Mercier will begin. He will have 8 minutes reserved for rebuttal. All right, you may begin.
This is an appeal of a denial for restoration of a license of Connie McKnight. In summary, and I'll get into further details, the
board panel denied the petition for the restoration. And the language contained in the order indicates that there was some confusion over the facts of the case because it indicates that there was need for certain types of action by Ms. McKnight, which would only have been necessary had there been a finding of some type of addiction or abuse of controlled substances. Ms. McKnight has been a registered nurse since 1993. At the hearing that was held here, I'm sorry, I'll turn that off. At the hearing that was held here, the board staff introduced a letter and an order from 2012. The 2012 order was when Ms. McKnight got in trouble with the board and she was penalized with a restricted license in 2012, and that's in the exhibits. That's MSBN 6. The board also introduced a letter, which is MSBN 13, dated September 3rd, 2013, to Ms. McKnight, which says that she had completed all of the requirements for that that final order that restricted her license, and that all the terms for removal of stipulations had been completed. Fast forward, Ms. McKnight in 2021 was before the board again on a matter, and this time she was charged with practicing while impaired. Factually, she fell asleep, seemed sleepy, groggy, couldn't operate her computer well, used the mouse wrong. And so she was given a reasonable suspicion drug test, which was high for amphetamines, and for which she had a prescription. Now, the test results indicated an unusually high amount of amphetamines, but that was a one-time test and there was no other test following that. As a result, the board issued a final order which is bear with me. Okay, the board issued a final order, and in its findings, they found that, I'm quoting, while under the influence of alcohol or other mood-altering substances, as evidenced by 3, impairment while on duty using authorized or unauthorized medications. And that, quote, witnesses observed responded as overly tired, falling asleep, sobbing, exhibiting a stiff gait and slurred speech, asking repetitive questions and having difficulty using the computer, including the computer mouse backwards, and an inability to enter physician's orders. And, quote, submitted to a reasonable suspicion drug screen on about 9/27/2020, the results of which confirmed positive for amphetamines at 132,360 NG/ml. That's exhibit B7, page 15. That there was charges against Ms. McKnight. She did not receive the notification of the complaint. The hearing proceeded without her, and as a result, she was revoked by the final order dated November 4th, 2021, from which I just read. Now, there's never been a complaint or any findings by this board that Connie McKnight was addicted to any substance or had a substance abuse problem. But the language used in the order indicated that she did have such a problem. Here, the language referring to in the final order dated June 24th, 2024 is this. Specifically, the hearing panel made findings that, quote, the panel considered petitioner's rehabilitation efforts, close quote. And that, quote, petitioner failed to submit any documentation or evidence to demonstrate current sobriety to the panel despite having been revoked previously by the board for practicing nursing while impaired, close quote. That's Exhibit A, page 2. Now, what the board's order did and said in revoking her license originally made no mention of addiction or abuse. It said that she practiced while impaired, which would be, it could be coming to the workplace, to the hospital, being drunk with a hangover. It could be coming, having taken too much of your pain medication. It could be coming as a drug addict or drug abuser, but that's not contained in any orders. We don't know. All we know is that she was found to be impaired that day. The board's order does not reflect any accusations of addiction or abuse, only that she was impaired that day. The board revoked her license based on that. She came back up here requesting restoration after several years. And the board entered its order with the finding that indicated it was their belief that she had some sort of requirement to present evidence to this board of rehabilitation efforts or current sobriety. But there's nothing in any of the records to indicate that she wouldn't be sober. That's like saying anybody that comes before this board has to present something that indicates they're sober. Even if there's never been an indication or a finding or an allegation that they are a drug abuser or a drug addict or an alcoholic or anything else. So that improperly shifts a burden to her for facts that don't exist. Additionally, there's a case, it's Mississippi State Board of Nursing versus Wilson that I cite on page 5. And that case essentially holds that there must be some sort of a temporal proximity to any allegations or findings of addiction by this board. I'll read this quote. In a previous nursing board case involving a decision by the nursing board that was based primarily on a licensee's past addiction, Supreme Court stated that, and here's the quote, any reasonable interpretation of the statute, however, would require some temporal proximity of active addiction to the disciplinary action. The facts reflect that since 1988, when Wilson finished his treatment at Harbor House in Victory Manor, he has not used drugs or alcohol of any kind. In the absence of a showing that the board applied a reasonable standard, the conclusion is inescapable that the decision as to addiction is arbitrary. We have the same thing here. There was never a finding or even allegation of addiction whenever her license was originally revoked. But even if there had been, the board would still be charged to put on evidence today that there's something indicating that the addiction or abuse is still occurring. It's not her burden to do that. It's her burden to prove that she should be restored based upon the prior revocation. But you're asking her to prove something that was never alleged. It's never been alleged. Yet that's what the board seized on, the board panel. Another case from Mississippi, Game and Fish Commission versus Marler. Supreme Court stated this, where a hearing or finding is required, a finding or decision without support in the evidence is beyond the power and jurisdiction of administrative agencies. It is contrary to law and void, arbitrary, capricious, unreasonable, or an abuse of discretion and may constitute a denial of due process. And then Anadarko Petroleum Corporation versus State Oil and Gas Board of Mississippi, the Supreme Court said it is a logical and legal prerequisite to intelligent judicial review in these cases that the board favor us with more than mere conclusory findings. Here, there are not sufficient findings in the board panel's order to support it. I'd like to reserve the remainder of my time, please.
You're at 11 minutes. Walker.
Thank you, Your Honor. Again, I'm not gonna rehash the facts. I think Mr. Mercer kind of stated on Miss McKnight was here for a restoration hearing. She, as he stated, she had previously, her license was revoked the last time in 2021. So because she was here for a restoration hearing, per the rules, let me just start with this. The appeal is limited to the record, so we can't go outside the record. That's already been established. And unless this board finds, excuse me, the full board finds that the decision by the panel was not supported by substantial evidence, was either arbitrary or capricious, was beyond the power of the agency to make, or violated some statutory or constitutional right, the decision has to remain the same. And so with that now, let me go back to where I was headed. Because this was a restoration hearing, Ms. McKnight bore the burden of proof. That's in the rules. At no point in a restoration hearing does that burden ever shift to the board to prove anything. She's here to prove why her license should be restored. That's in specifically Mississippi Admin Code 2825 Rule 1.4B5. We had a final order, as Mr. Mercier has already stated, in 2021 that revoked her, specifically for being impaired while on duty while using authorized or unauthorized medication. That was after she tested positive, as he already stated, to a high amount of amphetamines. That was a finding of fact found by the panel on that, at that hearing. That it wasn't appealed. That's taken as true. It is what it is. That was the finding of fact. There was your finding. It's not up for question. When Ms. McKnight came back for a hearing, it's on her to say why she has restored herself. In other words, why she should get her license back. She was found to be impaired. So with that being said, those findings, she had a positive test. I believe specifically it was 132,360 milliliters. They're not disputed. The instructions, and when at her hearing, she didn't present any rehabilitative measures. She demonstrated she was sober. She did not have any AA meetings that she had attended. She had done no drug testing. Matter of fact, she had done no CEU courses. Their instructions for the restoration application, or which are on the website, state that for revocation of a license that includes a charge of impairment, that applicant must provide evidence of 12 months of negative drug screens prior to having her license, making her application for restoration. She did none of those, not one. Why would the panel think that she did not have a drug problem now, if that's the very reason she was revoked? The rules, Mississippi Code annotated 73-15-17A, that gives the board the authority to promulgate rules. In Title 30 of the Mississippi Administrative Code, Part 2820, Rule 1.12A, it states that applications for restorations must be on forms prescribed by the board, and that all information requested on the forms must be included. A5 goes on to state that the board may not consider incomplete applications. Literally in the board rules. So applicants are required to submit continuing education. She didn't know that. She didn't present any evidence of any drug screens, as required. She bore the burden of clear and convincing evidence as to why she should be restored. She did nothing to prove that she should get her license back. If the panel had granted her license, they would have been in violation of the very rules that govern the board. There's also, as Mr. Mercier has alluded to, she wasn't charged with addiction, but she was charged with being found guilty of impairment while on duty by authorized or unauthorized medication. And as we already stated, it was extremely high amount of amphetamine that she tested positive for. She provided no 12 months of drug screens, and her license was revoked because of the impairment. There's also factors that are set out in the rules that the board is to consider. And that specifically is in 30 Admin Code Part 2825, Rule 1.12 D6. The first factor is the severity of the acts that resulted in the revocation of license. Okay, she tested positive for a high amount of amphetamine, was seen sleeping on duty, was observed slurring her words, and was unable to work a computer mouse according to the order. So in looking at the second factor, appellant's conduct prior to the revocation of her license. This was their second disciplinary action for the board. The third factor is her compliance with the restoration requirements. She didn't provide a single drug screen despite the fact that she lost her license for impairment duty. She provided no evidence that she attended AA meetings or peer groups. And she provided nothing that she had done any rehabilitation efforts. She didn't take any educational courses. She'd done nothing. The last time she practiced, or her license was revoked in 2021, she'd taken no continuing education courses. So that there was, she did nothing to prove her case. Again, it's very important to remember that the burden was not on the board. It was on her, per the rules. She also argues that because there was no evidence that she submitted her sobriety, that this was unreasonable. And because this conduct was 4 years ago, that it's also irrelevant, so it doesn't relate. But like I've already stated, she bore the burden. Again, the burden doesn't shift at any point in time here. She provided nothing to show why she should be restored. So this decision didn't violate a statutory provision because there was nothing presented. She lost her license because of that charge and impairment. And if you look at Mississippi Code's annotated 7315-31-7, it states that the board has the discretion to reinstate a license or to restore a license, excuse me. And it doesn't say, it says literally the board a revoked or suspended license may be reissued after 1 year in the discretion of the hearing panel. It doesn't say that they have to restore the license. So clearly if the panel thinks that there needs to be something more, it's at their discretion. It does not have to be reinstated. Appellant also argues in a brief that there was no clear connection with the decisions, with the panel's decision and any current misconduct. So there's not it violated due process. The decision was based on a final order that was dated November 4th, 2021 that revoked her license for impairment. And as I already stated, that has to be taken as fact. That was a finding of fact by the panel. She said this, the appellant did absolutely nothing to show that the circumstances that surrounded her revocation had changed at all. There was no reason for this board to restore her license. So granting, as I've already stated, granting appellant's petition when she presented nothing to show a change in the circumstances from a drug-related issue, that in her initial revocation would go against the legislative duty that's been put upon the board, and that's to protect the public from incompetent nursing practices. There's also an argument that it was arbitrary and capricious, because it was based on irrelevant past actions. I'd have to argue that the past actions can't be irrelevant when you're coming for restoring a nursing license. That's, you're again trying to shift the burden to the board to prove why you shouldn't get your license, when in fact, it's clearly stated in the rules that the appellant has the burden. It's their burden to prove why she get it back. When a nurse loses her license, it is this board's duty to determine why she lost her license and if she's made efforts sufficient enough to get her license back. There's never a shift in burden. I think that's very important for this board to remember and realize. And because of the reasons I stated, she like again, I said, she did nothing. She provided no drug screen. She provided no AA caliber. She did no continuing education. She literally did nothing to provide any, just a slimmer of evidence that she had tried to rehabilitate herself. Regardless of what she had done in the past, she didn't meet her burden. And for those reasons, I would ask that the full board affirm the decision of the panel. Thank you.
Ms. Mercier, you have 9 minutes in rebuttal.
Thank you. Mr. Walker spent a good bit of time speaking about burdens, and he repeatedly said that it was Ms. McKnight's burden to prove that she had done this and hadn't done that. Well, what she has to prove has to be objective and not subjective. And the objectivity comes from what she was charged with and the reason she was revoked, not what happened prior to that, not what happened since then. It has to be objective, and objectively speaking, what she was revoked for in 2021 is contained in the order, which is dated November the 4th, 2021. And I read from it earlier, and it says nothing about being addicted to any type of medication or drugs, or being or alcohol, or abusing them. It simply says that she was impaired while on duty. And she's been punished for that. She was punished for that. She comes back to this board and she says, okay, this is my proof. Now, it is the burden of the board panel to base its decision. This is the law, to base its decision on the evidence, substantial evidence. It's got to be there. It's not her burden to come up with something that may be subjective, but what the actual facts are. And the facts are she was revoked because of impairment while on duty. But let's talk about burden one more time. And this is the last time I'll bring it up. Under 73-15-31, subparagraph 4. That addresses what happens at a hearing and then what happens afterwards. Specifically, I'll read the last sentence of that subsection. Quote, a final decision by the hearing panel and by the board on appeal shall include findings of fact and conclusions of law separately stated, of which the accused shall receive a copy. End quote. Ms. McKnight was never provided a copy of the final order. Anyway, that's a burden of the board, not Ms. McKnight. That's a burden the board cannot shift to Ms. McKnight. They couldn't find her. That's the reason she wasn't here. They didn't send her a copy of the findings of fact, conclusions of law from the final order. She continued to work. The only way she found out about the board's final order was from her work. They came to her and said, oh, you know, your license has been revoked. And that was some 6 months later. The board never sent her anything. I keep referring to the 2021 final order, where it states the findings of the board. Nowhere in those findings, nowhere does it say that she is found to be an alcoholic, addicted, dependent on drugs, or anything similar to that. It simply says she was impaired that one day. And in the board's order, the current order, you'll bear with me while I get to it. Twenty 2024 order you're here on today doesn't even resemble what she was revoked for. It says, as I mentioned earlier, that the panel considered petitioner's rehabilitation efforts. It says, let me just read it. At the hearing, the panel considered the severity of the acts that resulted in the revocation of petitioner's nursing license on November 4, 2021. And further consider petitioner's conduct after the revocation of her nursing license. There was no evidence in the record of any negative conduct after the revocation of her license, other than the fact that she continued to work until she was informed by her employer that her license had been revoked, including petitioner's continued employment as a nurse after the revocation of her nursing license. To this point, there's nothing about alcohol or drug abuse or addiction. Moreover, the panel considered petitioner's rehabilitation efforts and did not find that she had demonstrated competency to practice nursing or demonstrated the ability to safely practice nursing in compliance with the requirements outlined in 30 Mississippi Administrative Code, Part 2825, Rule 1.12 D6. Petitioner failed to submit any documentation or evidence to demonstrate current sobriety to the panel, despite having been revoked previously by the board for practicing nursing while impaired. End of quote. Yes, she was revoked for practicing while impaired, not for needing to go into treatment, not for needing, not for being addicted or abusing drugs or alcohol. So to put the burden on her to demonstrate current sobriety when there's never been a finding of not being sober is unfair. And it shows that the board panel misconstrued the facts and what was reported. Otherwise, what you're saying is that if someone is coming before this board, they have to guess what this board may be looking for them to present. They can't look at the prior order and go from there. They can't look at the rules and go from there. They have to guess what the board panel may decide they want to hear, but that's not the law. You know, the law is clearly stated in what has to be presented. And she presented what was required. The board chose to interpret, I don't know what, I don't know what they were really looking for, but they chose to look at something that was not here. They may have chosen to interpret the fact that she was impaired that one day as needing sobriety or whatever, but there was never a finding of that. So for that reason, we'd ask that the full board reverse the finding in the order of the final order that denied the petition for restoration.
Thank you. Okay. Does the board have any questions for either party?
I think I have one, and I want some leeway here too, because I think this falls within that review for substantial evidence. The case, Mr. Mercier cited, I think it was Wilson case, or the Board of Nursing case. Do you not find that case to be applicable here, or how would you respond to that?
I'm not sure.
That's a temporal proximity case.
Are you asking if I find that to apply
Yeah,
here?
yeah, I mean, it seems there are some.
So, I mean, I'll answer within,
practices here.
yeah, so I'll answer within the statements of the brief and the rules. The rules state that if that you have to abide by the restoration requirements. The requirements are posted on the website with the application. That states that if you, as I stated in the brief and as I stated a while ago, if there's a licensee loses their license due to revocation, or I'm sorry, due to impairment or a drug-related offense, they show 12 months of negative drug screens and AA meetings. That's what it states in the regulations that were promulgated and on the requirements that are posted on the website.
But I think that case, as I read it, the excerpt seems to talk about there has to be some proximity between the time that, the offense occurred and then the later.
Right, but she wasn't being charged. Again, this was a restoration hearing. That had already occurred. She lost her license in 2021, as was stated, because of that charge. At that time, that would have been the time for any evidence to be presented for that to be disputed and whether it's a temporal proximity. At this point in time, she's coming to get her license back.
And Mr. Mercier, just to clarify, your argument was that she didn't receive the order from the board that delineated those requirements. Did I hear you correctly? She was not made aware of that?
No,
Okay.
no. She did not receive a copy of the board's order whenever she was not present here and it was revoked. She did not receive a copy of it as required by statute. Now, the order itself, though, did not list the things that Mr. Walker said, that she was required to have drug screens, submit an NAAA calendar, take education courses. None of that's contained in the order. You can see that. So regardless, I mean, that was not in the order, even if she had received it. No, but she never received it as required by statute.
Okay, but it appears to me she didn't receive it because there's a whole page here of the deposition or the court reporter that she apparently didn't know her address. They went back and forth on that, but anyway, neither here nor there. And then you made a statement about the addiction piece, I understand, but she demonstrated not being sober. Help me understand something about sobriety or her being sober earlier. I was trying to write down as you spoke.
That's what it says in the panel's order.
Okay.
It says, let me get to it's in my brief. It says.
I don't think we can refer to the brief at this time. I can only speak to what's on record.
That is the record.
Okay, okay, okay. Yes, sir.
Let me just give me 1 second and I'll get to it. That's what we're appealing from. Here it is right here. Okay. That's the language in the final order that we were appealing from that denied her. It's the June 24th, 2024 order, final order. In the findings, it says that she failed to submit any documentation or evidence to demonstrate current sobriety.
Additional questions from the board?
I mean, are we supposed to send it by registered mail so we can get a receipt that she received the orders and?
That's going to be outside of this part of the record, okay? So.
Oh, okay.
Any additional questions regarding the appeal? Hearing no further questions, this will conclude the hearing on the matter. House number 2024-0306 in the matter of Connie McKnight versus Mississippi Board of Nursing. At this time, I'll entertain a motion from the board to go into executive session. The board has grounds to go into executive session. I'll make that motion. Okay.
Second.
Made. At this time, I will entertain a motion to go into executive session for the purposes of deliberation in the appeal of this matter. I'd ask, do I have that motion? Motion. Any second?
Just
Any discussion? Any, all in favor?
Aye.
The board has unanimously voted to uphold the hearing panel's final order. This completes the hearing in the matter. And the board is now adjourned.
Well, thank y'all for another great. Guys.
Where do you live?
And y'all all be safe traveling home.
I will. Oh, okay. Well, y'all have fun. Okay. You loaded up?
Yes, sir. Early March.